Thank you once again for making time for the event. Uh, what I could do is I could first introduce who we have on the panel and how we plan to conduct the session today. Uh, so I'm Richi. I lead the fund formation practice at the firm. Shrikant is a senior member of the team, and so is Nandini. Shrikant helps more on the FPI, on the custody, as well as Category 3 AF's perspective. So, panel 2 is focused on those sort of open end fund structures and the issues that we're facing. Nandini, on the other hand, focuses by and large on close end funds. Close end funds again include the entire range of products. It could be VC, private equity, distressed growth, and so on and so forth. Uh, so with that, maybe if I could just gauge the the audience make and so on and so forth. I see a lot of custodians. I see trustees also in the room. I see fund managers as well. So any specific areas of interest that you have, or if you want us to pause on some issues, or if you think that the topic is something different from what you are keen to understand, then maybe just tell us what you want to hear. Within our collective wisdoms, whatever we can share, we'll be happy to do so. Uh, okay. So maybe I'll just quickly introduce why we thought this is an opportune time for discussing key fund terms, legal considerations. What had happened is last year India saw about $26 billion worth of exits. $22 billion came in, which is one of the only three instances historically where India saw was a net capital outflow sort of a country. India has always had the appetite to absorb billions of dollars of foreign capital, but not to return. So last 2 3 years have been a very pleasant surprise. A lot of exits was led by a couple of mega transactions. You saw Walmart's acquisition, so on and so forth, which obviously gave liquidity to a lot of AIFs, a lot of funds, VCP funds that had invested throughout the life cycle of the Flipkart as an entity. And accordingly, a lot of LPs saw distributions, which obviously renews their faith that, okay, as an asset class, India is sort of maturing, and at least one of the critical emerging market risks is now off. India can distribute cash flows. Uh, so I think that was one great story to speak of, and obviously there are very thematic funds also which we have seen, like distressed funds in the last 2 3 years. A lot of raising has happened. You will suddenly see those funds making allocations to India. We'll talk about that also. Uh, so that's more on the close end fund side. On open end fund, which we plan to do as a separate session after hour and a half, we will focus on the FPI regime, the Category 3 AF regime. We'll also spend some time on the HR Khan committee report, as I see a lot of bankers and custodians in the room, on what are the proposals, what are the issues, whether we agree with some of the recommendations or not. Happy to hear what are your thoughts, what are the restrictions or what are the issues that you yourself face, and our 2 cents of our own views, basis feedback. We'll also touch on Gift City, where we are right now. How far are we from launching a live platform out of Gift? What are the current tax or regulatory challenges that we see? And is there a meaningful solution coming out of Gift in next quarter or so, especially around the fund side? Like the exchanges are there, the operators are there, the entire infrastructure has been laid out. But when would we see AIFs or pooling vehicles coming out of Gift? Uh, so with that, maybe I could maybe request Nandini if you could start on the close and fund side. Uh, what are the strategies and structures we talk about, and I can add from time to time.
Sure. Thanks, Richi. So, we have tried to design the masterclass in a way that we design a fund. So, we'll start with formation and then we'll go on to fund terms. At any given point of time, if you have questions, please feel free to ask, though we have reserved 15 minutes at the end for questions. Um, so to begin with, we've always maintained that structure follows strategy. When we are discussing with the GP team how they would want the fund to be structured, we first try to understand these broad strategic points from them. Uh, the intent here is to discuss why each of these points are relevant for designing the structure. So, starting with the targets. broad targets, you would always know the kind of investors you would want to tap. Now, for example, if a purely domestic pool of capital may have less complications as compared to a mix of USD, INR, European investors. So, in terms of designing the waterfall, fund economics, LP rights, it becomes relevant who are the kind of investors you're tapping. In fact, even from a marketing perspective, at the time of marketing itself, there are certain restrictions that kick in. So if you're going to US investors, European investors, there may be certain local marketing rules applicable to you. So at that stage itself, discussion with the lawyers becomes relevant. In terms of corpus, that's relevant to understand the capacity of the structure to consume costs. If the corpus is relatively small, then we would try to avoid structures which would require a lot of vehicles or a lot of accounting complications, so that it is cost efficient for you to operate the fund as you go along. In terms of portfolio and jurisdictions, it's relevant the kind of companies that you're looking at, the kind of portfolio entities, I should say, you're looking at, and also the jurisdictions. If it's an India only fund, then the structure considerations would be different as compared to maybe a global fund with a pocket of India allocation. So when we go on to the structures, we'll discuss how these items play out. Similarly, in terms of themes, investment strategies, both of these become relevant while designing whether you would want to do a master feeder structure, a co-invest plus a master feeder structure. And in terms of GP considerations, now let me just show you one structure. So here, when we look at the GP side of things, which is on the right hand side, the investment manager, the structuring for the manager becomes relevant from these perspectives, right? If, for example, it's a joint venture between two GPs, we've seen some in the last year, then the considerations for a new entity to be set up, the sharing of economics between the two would be relevant. If you are starting out the first fund with that GP entity, then the risk disclosures and the risk ring fencing with the fund also becomes relevant. For example, if you have certain individual sponsors in the GP team, would you want them to take direct exposure to the fund towards sponsor commitment and carry, or would you want to ring fence them by way of entities or trusts in the middle? Uh, then, in terms of economic considerations, in addition to carry and sponsor, you have management fees considerations. We will discuss how LLPs and companies are two most popularly considered legal vehicles in India for the GP entity. On the structure side, these are four common structures that we see with respect to India focused funds these days. I'll start with the master feeder structures. Here, we typically have the feeder entity established in a tax neutral overseas jurisdiction. What I mean by that is the investors participating through that tax neutral entity should not be worse off than what they would have been if they were to come directly into the Indian fund. There can be non-tax considerations for for there being a feeder entity outside of India, which could be the presence of a bilateral investment protection treaty of that feeder jurisdiction with India. Bilateral investment protection treaties hold very important relevance for foreign institutional investors or DFIs, because they would not want to directly take exposure to a country which does not have investor protection in place. Um, Other than that, some investors have doubts about enforcement regime in India, whether the courts are still efficient, whether arbitrability is enforceable. So they would want contractual enforcement of rights in another neutral jurisdiction instead of taking direct exposure to India. We've written Singapore slash Mauritius as the two jurisdictions for the feeder entity because they continue to be most preferred when looking at India. But there are other jurisdictions which can also be considered if you have the cost appetite for it. So you can look at Luxembourg, you can look at Dutch entities, but they are very expensive. Uh, Even between Mauritius and Singapore, we've seen a lot of GPs choose perhaps Mauritius over Singapore for cost reasons. And Singapore is relatively heavier on compliance as compared to Mauritius, is what we understand. So the way this structure works is you would have a set of foreign investors who would have the considerations that I just mentioned of a bilateral investment protection treaty, etc. The others, however, would have different set of considerations, like a direct counterparty right against the GP team, for which they would want to participate in the AIF directly. So catering to both of their needs, you would have ability in the AIF to issue one class of units to a feeder vehicle and the other class of units to your offshore investors who would like to come directly into the AIF. And then you would have your onshore set of investors also participating directly at the India level. There is an overlap between overseas and onshore investors when it comes to NRIs, but then depending on the account that they are choosing for investing, you can take a call. Marketing restrictions, however, would not depend on which account the NRI is using. For example, in Japan, if you were marketing to a Japanese to an NRI investor, even if they were using an Indian account, the fact that you were physically marketing the fund to them in Japan could subject you to marketing restrictions. Then, in terms of the sponsor and the manager structure, generally we see the same entity taking both the exposures, but you have the flexibility both from SEBI and from a tax perspective to design it differently. Uh, we have seen even employee welfare trust structures come in the middle of the manager sponsor entity and the fund for different commercial reasons. uh, but yes, if you have a foreign presence in the GP team, then there are different considerations. Perhaps an employee welfare trust could be tricky if you have to upstream some economics to foreign participants of the GP team. In terms of foreign exchange control regulations, you would see an arrow from the onshore fund to the portfolio explaining the kind of instruments that are eligible for investments. We've specified this because generally we get questions about FDI policy being applicable to the fund because there are overseas investors. There is a special case for foreign investment in AIFs under TISPRO regulations, which is the foreign exchange regulations governing the structure, where if the AIF is managed by an Indian owned and controlled manager, then despite receiving foreign investments in the AIF, the AIF's downstream investments should not be subject to the FDI policy. So perhaps we can later discuss the nitty gritties of Indian owned and controlled. Other than that, in terms of documentation, it is very important to ensure you do not undermine the substance of the feeder entity. Your overseas investors who are participating through the feeder entity would want direct counterparty rights against the manager as much as possible. However, your dialogue needs to be clear that they are making a choice between coming directly into the AIF versus the feeder, and therefore there would be certain cons that they would need to deal with. It's a trade-off for them, so that you cannot give into certain direct counterparty rights for various tax and legal reasons to investors of the feeder entity. I'll give you an example. If there was a key person event, say, triggered at the AIF level, they would want the ability to directly take actions at both the AIF and feeder level. However, their actions should be limited to the feeder level. There is no direct participation in the AIF. So, to that extent, they will require the feeder entity to take actions against the AIF. So these are some
Just
key
to
points.
just to add, I think two other considerations which can be important are the hesitation which some foreign investors have to take up a PAN in India and be directly under the purview of the Indian revenue authorities, which is a part of the reason why overseas investors can split into those who are comfortable and coming in directly and those who are not so comfortable and would prefer a feeder to do all of that Indian tax compliance for them. Another increasing set of questions we're getting with respect to feeders is ability to leverage, because in PEVC structures, the onshore fund is most likely structured as a category 1 or a category 2 AIF, which have certain restrictions, or rather quite severely restricted in terms of the fund's ability to leverage. So we are also looking at GPs trying to figure out whether the feeder can also be used to enhance the platform's ability to leverage. Of course, there are a lot of challenges and things to think through on that, but those are increasing sets of questions that are coming up for us.
The next structure is co-investment. Now, we earlier co-investment structures were relatively more popular. By earlier, I mean before the foreign direct investment ability that we discussed with respect to the AIF receiving foreign investments. uh, because it was indifferent for the offshore fund to invest directly or through the AIF. If the offshore fund invested into the AIF pre the FEMA benefits that came in, then the onshore fund would have been subject to the FDI restrictions while making investments in the portfolio. Now, there are several benefits of a unified or a master feeder structure versus a co-invest structure. Other than this, you have the ability of consolidating the corpus at both the levels. You have the ability to charge economics only at the India level, and you do not need to split it between two different vehicles. But there are certain commercial considerations which could still make this a more efficient structure. If you actually have an offshore element in your GP team, uh, or if there is a joint venture which requires two different pooling vehicles, then something like this could still be considered beneficial. One more reason why you may want to choose this is the ability of the offshore fund alone to make overseas investments. So perhaps your overseas pool of capital is comfortable with making non-India investments, but your Indian investors are the kind who cannot remit money outside India and can only take exposure if you invest their monies into India. Then again, you could consider perhaps this structure or a combination of master feeder and this structure, depending on the appetite for cost. Third is a recent structure that is coming up. Richie touched upon it briefly. We have seen a circular coming out last year on how AIFs can be set up in the Gift City or other international financial services centers in India. uh, we believe that there is some more clarity required from a regulatory perspective on how an AIF can actually be structured. For example, it's unclear right now as to how the sponsor capital will move from India to the gift city manager for the regulatory requirement of a GP commitment into the AIF. Uh, Other than that, the licensing requirement could also use some more flexibility. One school of thought after the circular was you do not need multiple licenses. If you are an IFSC pooling vehicle, then perhaps you could combine the FPI, AIF, FVCI framework like a special license and then use that to look at India. I think these are currently being considered. One progress with respect to Gift City was the approval of a unified regulator. That really helps because SEBI right now is, we understand, overburdened. There are a lot of delays at the end, and there was some shuffling within the team as well. So this it would have been an additional difficulty for the regulator to also look at gift city AIFs. The unified regulator also has the power under the legislation to come up with its own rules and regulations with respect to IFSC AIFs. So perhaps the whole procedure in India to amend the regulations could be done away with respect to at least IFSC AIFs. We can get quicker clarifications with respect to operations in the gift city. So that's something that we are looking at positively.
Yeah.
Yeah.
Good.
This IFCAF is more or less of feeder entity type considered,
Uh,
or the offshore fund it will be considered.
yeah, no, so I think so we'll break that statement up. It can operate as both. To begin with, an IFSC AIF can operate as a feeder to a domestic AIF. Motivation one could be that can we save on GST, because any services rendered no GST. There is also a school of thought that if carried interest is recharacterized as business income instead of capital gains, then also because there is no GST, then at least there will be some saving on that account also. So IFSC could also act as a good feeder to a domestic AIF. Having said that, it is still not been made clear that if a foreign investor comes directly into a IFSC AIF, will they need a, or can they avoid having a PAN? Can they avoid filing tax returns in India? So the proposal seems to be that they will be required to get a PAN if they come in directly at the gift AIF. But at the same time, the gift AIF, the rules which we are envisaging would come into play, would say that we will deduct the tax at the effective rate. So it would mean that it's not a TDS. The full tax has been deducted at the AF level. So foreign investors will not have to file tax returns. But till the entire environment around tax stabilizes, we would expect that foreign investors would prefer a feeder on top of the gift AIF. Only then, and not directly coming into gift AIF. If their motivation, like Shrikant indicated, was to avoid India tax administration and so on and so forth. As far as investments into India directly is concerned, right now what has happened is because we don't have any pooling related rules and regulations in gift. So what SEBI has very conveniently done, and one can expect, is that they said that if you pool investors directly in gift, you look at the AF regulations, because AF program is the only pooling regime we have apart from mutual fund regulations, right? Everything else is like either a PMS which is no longer pooled, it is depooled basis, and so on and so forth. So very conveniently we applied the rules that anyone pooling investors in gift, please look at the AF regulations. Now that has also led to a lot of difficulty. Like Nandini indicated that if a gift city based AIF, so when you're setting it up, it would either be a category 1, 2, or 3. A category 2 AIF literally means that it cannot invest more than 25% in a single opportunity. A category 3 cannot invest more than 10% of its own corpus into any single opportunity. On the other hand, a gift AIF, when investing in Indian liquidity, they'll have to go for an FPI license also. An FPI, by the way, by definition, cannot invest more than 9.99 of an Indian company. So then we are going to look at a mishmash of two different restrictions coming from two very different objectives. AIFs are restricted on their corpus because they want to diversify the investors' risk who are coming into an AIF, like at least spread out over 10 investments. FPIs, on the other hand, have been asked not to invest more than 9.99 because they are investing in public markets, retail money is also involved, so we don't want too much volatility attached to one foreign investor. But if you have the same vehicle attached with both the two restrictions, how would the regime sort of operate? So some clarity is awaited that if an AIF has been set up in GIFT, can it only look at the FPI restrictions and not look at the AIF restrictions till a meaningful pooling vehicle regulation is sort of designed? The other piece is, again, I was just hearing, I don't know where it is right now, that the chairman of the unified regulator could be the chief minister. So that definitely helps from a marketing perspective. So again, don't quote me on that. It's just something I was hearing, and it's quite interesting because on one hand you have 8 members are there. One from SEBI, RBI, PFRDA, IRDA. There are four Minister of Finance guys to balance so that you don't have independent views coming out like RBI and so on and so forth. So just to so because ultimately you have to understand that the unified regulator will be the single nodal regulator for anything to do with gift. So how much independence can there be, or how much the government can have an influence? So a lot of those things are relevant, and the chairman also, I think, If the appointment were to go through, it would make some sense. So that's how we are looking at gift right now. And sorry.
There's no clarity on whether bilateral taxation treaties and all will have.
So from a tax perspective, GIFT is in AIF, is in India territory. So it is part of India. So the entire framework, as far as tax treaties are concerned, frankly, that's the very basis on which you'll have to get a PAN or file tax returns, right? If you were not part of the Indian territory, then unless you have a business connection or a permanent establishment, you don't have any India tax exposure. If you're a completely foreign territory entity. So all those India tax rules come into play just because you are still part of India under the SEZ norms. So IFSC is also part of the SEZ legislation. So from fiscal, you're part of India. Yeah.
Just maybe extending it to your conversation and an interesting point on recharacterization of the carried interest to business.
Right.
Can that be, basis your thought, can that be also applied to the fund income as well? So today in hereditary you have a capital gain which is arising to the fund. Can it be recharacterized as business to avail of certain, tax concessions which are otherwise?
See, that could be little tricky, and I'll tell you why. Because if you are investing in listed shares, then when you invest in India, you will be investing under the FPI license. And under the Tax Act 2014 or 2015, they amended the law to say that any investment you make, it will be deemed to be capital asset. So that argument, whether it is business income or capital gains, is unfortunately not there if you're an FPI. If you're an FDI investor, then perhaps you could take a view, but obviously there are tax avoidance rules also which will kick in. So we'll have to take care of that. Another point we can also consider is that GIFT was designed to onshore the offshore. GIFT was not designed to onshore the onshore. So you would have to move some investment managers, the team, some good CV in GIFT so that you can make a very valid claim that okay, give me the GST related concessions or the business income related treatments. If you were to sort of rely on that, you would definitely need some team, some substance, some decision making capabilities residing within GIFT for you to sort of avail those.
Also, for a category 1 or 2 AIFs, today the way, like Richie said, it is treated to be Indian resident for tax purposes. So the moment you characterize it as business income, your pass-through stops applying because business income is not a pass-through stream of income.
Yeah, but typically, when you look at the CBDT circular, there's always an inherent concept of you defending between a capital versus business, and which is where that could be an advantage if there are thoughts around that.
Yeah, see, the challenge with that is that, see, even if you were to consider that the income of the AF is business income, like Shrikant indicated, it is taxable at the trust level, but at the same time, if you take a view that the business income is covered under Section 80 LA, which is under a tax holiday for the first 5 years and 50% rebate for the next 5 years, and hence zero tax leakage. But again, a fair view to take is that don't look at the income of a fund as a business income, especially if it's a category 1 or 2 AIFs. Look at it again like capital gains in nature.
So we've been always arguing that you're always in the business of making investments. So maybe that could be one of the reasons where I thought this argument should sustain with some of the tax rates. Of course, there's no application of mine yet with the tax authority, and then which is what we can expect something from the budget.
Sure.
So, is there any evolution on how onshore investors get treated at the IFSCI? So, is it considered under the 250,000?
Correct.
Yes,
LRS.
that's
LRS.
LRS.
Yeah.
And therefore, then how does the sponsor commitment?
So like Nandin indicated, right now there's an ambiguity. The view we have got from some of the bankers is that RBI application will still be required, but those approvals will be forthcoming because unless you allow Indian sponsors to sponsor an AIF in gift, the entire regime would be a non-starter. So A and RBI approval will be required, but it should not be a showstopper.
And what would happen if you have Indian institutional investors who need or whatever master outside IFSC? They would also then be.
I
For
don't
example,
think.
insurance companies.
Yeah, so I think that's where I think there will be a major challenge because Insurance Act IRDA does not
Yeah,
permit
sure.
insurers to invest abroad, and GIFT is deemed to be an offshore from a investments perspective. So I would.
So
While SEBI has allowed for Indian resident investors to invest under LRS scheme in the equity AIFs, how is RBI pursuing it?
RBI has
If
also
those
had
AIFs, equity AIFs are investing back in India.
No, so that is pretty much the prerogative of the program. That we would like the gift city based AIs to be an effective pooling vehicle for not just overseas capital but also for onshore capital. Hence the clarity in regime that okay, allow LRS participation and allow Indian residents to also participate. If the gift city based AIF were to invest only in offshore opportunities, not even invest in India, then that is also very much
Permitted.
possible because only if they're investing in India, then you have to go for an FPI license or an FEC or an FDI. But if you're investing abroad, all sorts of limitations have been knocked off. That entire industry can invest up to 750, nothing applies. So technically, a gift AF2 can be a good capital exporter from an Indian perspective.
I was saying more perspective of whether RBI is pursuing the round tripping or if money is coming back in India.
I wouldn't think so for the simple reason that RBI is open to give approvals for the sponsor commitment to go in, and any Indian sponsor sponsoring a fund would by and large be India focused or some India thematics would be there. And B, this entire SEBI circular came out expressly stating that Indian residents can also invest and so on and so forth. So it would today we are not in that era where the regulators are not talking. There is a lot of inter-regulator discussion. So I wouldn't think that one regulator would take a completely diametrically opposite view to another regulator. Not in today's 2019, 2020. Okay.
So the next is the ARC structure, which you would like to discuss.
Sure, maybe. Yeah.
So ARCs, like Richie mentioned, this distressed asset is becoming quite a popular space, or at least a lot of fund managers are looking at it. The way ARCs work is slightly different. So one, you have already in place an asset reconstruction company which is registered with the Reserve Bank of India. That is similar to an NBFC, but a more specialized vehicle for securitization of assets. And how they operate is that they acquire loans or they acquire other financing and they securitize them through securitization trusts. And what is issued to investors is essentially security receipts, which are indications of beneficial interest in the particular loan that that trust has acquired. There is a mandatory 15% investment that is required in every tranche of security receipts as per RBI regulations and SARFAESI. But the remaining 85% is completely open for offshore participation as well. So when you're looking at offshore pooling of investors and offshore participation, there is a case to be made for an FPI setup where an FPI can invest in the security receipts. Uh, However, because of certain grays, possibly it may not be ideal for the same entity to also make FDI investment. So, if there is some level of harmony between the trust and the ARC and the portfolio, and there is a recognition that the portfolio itself may also need further funding through other routes beyond just the money brought in by the securitization trust. Sometimes the portfolio is also funded through the FDI route through an equity CCD structure. From a tax perspective, how this helps is like Richie mentioned, there is a non charging of tax from an India perspective if the income earned is business income and you don't have a permanent establishment or a business connection in India. In that situation, the practice among many of the securitization trusts has been to characterize the income received from the portfolio as business income and upstream that as business income. There is a clear tax pass through provided even for securitization trusts. So, if the offshore FPI is then able to take the argument or the stand that this is business income that it's receiving and it is not possessing any permanent establishment or having any business connection with India, then they should be able to get a largely tax neutral treatment through the investment in the securitization trust. So,
If you have any questions on these structures, otherwise I can just add one more comment that while ARCs are used to allow foreign participation into distressed sort of space. We've also seen foreign participation coming into standard assets. They come through the PTC structures, pass-through certificates. Those are not the security receipts as we typically know. So what you can do is you can collateralize vehicle loans, consumer loans, home loans. We ourselves last year, it's public now, had advised Oak Tree when they'd done a transaction with DHFL at that point in time. So there are parallel regimes for securitizing any sorts of bundles of loan. It could be either stressed or it could even be standard assets. And there are RBI guidelines on standard assets as well that apply and kick in case you're thinking of those. Okay. Uh,
So, from structures, we move on to fund terms. We've tried to classify these terms broadly into these four brackets. Starting with governance, this is again very specific to PEVC strategies. For open ended strategies, the fund terms, in addition to these, could take different forms, which we will discuss in session 2. Typically, for a PEVC structure, you would require an LP advisory board, which consists of representatives of your investors. Investors typically require that the manager does not have representation on the advisory board. Sometimes they do not even allow the manager to attend meetings of the advisory board. This is because the role of the advisory board is to discuss and approve matters of conflict, matters where the manager is digressing from the investment policy. This is key person event related items, replacement of key persons when a key person event is triggered. Uh, However, advisory board approvals cannot replace or substitute investor voting items. We have to be careful not just from a SEBI perspective. SEBI requires some, if there is a material amendment in the fund strategy or the documents, then you require a 75% LP consent by value. Uh, if you are prematurely terminating the fund, then again you require a 75% LP approval by value. Advisory board, on the other hand, vote basis value of investment. It has one vote per member typically, and that changes the dynamics of how the voting would work drastically. So, in terms of at least items of conflict, replacement of key persons, it is considered that the advisory board needs to act quickly and needs to act in the best interests of the fund and the other investors. Therefore, one vote per member is considered more efficient. However, we need to be careful not to provide any fiduciary obligations or duties to the advisory board members, because your investors would typically want a limited liability with respect to all their interactions with the fund and the manager. And that liability generally is limited to the amount of their commitment into the fund. The moment you introduce any fiduciary obligations or duties on the members of your advisory board, their liability under law would not be limited anymore. Uh, they could be sued by other investors into the fund who are perhaps not represented on the advisory board for breach of fiduciary if those investors don't consider the decision of the advisory board favorable. So, in order to balance between the needs of an advisory board and also limited liability requests from the investors, the documents should be designed carefully and the roles and responsibilities of the advisory board should be clear. You shouldn't even have to apply any bright line tests or interpretation rules when deciding what the advisory board's powers are. I'll give you an example. Valuation review of valuation of the portfolio or of the fund accounts, that's something that the investors usually insist the advisory board should be able to review actively. However, GPs have been very careful in telling LPs that you get the right to object if you feel valuation has not been done appropriately, rules have not been applied properly. You will get direct access to the auditors of the fund, but that's about it. You cannot substitute the role of the auditors in the fund and start first hand reviewing the valuation. Uh, Next, on key person events. For key person events, we've been seeing a lot of variations in different funds. Again, depending on the series of fundraising. If it's your first fund, then LPs are going to be a bit more circumspect than say a series 3, series 4 fund when they have built a confidence towards the GP team. Uh, in terms of what the contours are for key person event negotiations, identification of key persons. Uh, Typically, we saw individuals named as key persons in the fund documents, that these are the three people who have to dedicate their business time to the fund for the fund to not be in a key person event situation where we are worried that no one's paying attention to the fund. These days, with say series 3, 4 funds which have from a small GP team progressed into an institution, they have started using designations to identify key persons. So perhaps fund team leaders or investment team leaders. Now you can replace those individuals for those designations even before key person event is triggered, as long as you have necessary approvals. Uh, Second is position based key person triggers. So you can divide the key persons into different categories where you have the super key persons whose lack of time commitment would trigger far severe consequences as compared to say standard key persons who are relatively at a junior level. So perhaps you would not move the fund into termination mode if it was a standard key person event, but you could if it was a super key person event. uh, then how do you determine business time? It's so far it was a subjective analysis. The business time of the CEO would be determined differently from any investment analyst's business time to the fund, right? But now there is a increasing request from both GPs and LPs to have more objective criteria to determine when the business time is breached. Perhaps a percentage based formula or a point based system. These are different ways in which, or a hybrid, these are different ways in which people are designing the key person event. Uh, Also, there are the consequences of key person event are changing. The timing for your ability to cure, should it be 3 months, 6 months, 8 months? Should it lead to suspension of the commitment period, or should it lead to severe consequences like termination of the fund, or should it be a mutual discussion? These are other negotiation items with respect to key person event.
Sorry, go ahead.
Yeah. Do you think this advisory board adds value to the fund? Because we do not find that they have powers. Basically, for anything, we need to go to the investors. So, do you really think that in practical aspect, this advisory board adds some value to these funds?
So let me put it this way: a lot of these terms that are being discussed are meant for institutional fundraisers. A lot of funds today we are designing has sovereign wealth funds from Singapore, from Dubai, uh, and central government backed agencies coming from US, Europe, and so on and so forth. So what is happening is that they want some visibility on what's happening on ground in India. If the fund is India focused, the team by and large may be in India. So there are situations where they want some monitoring rights. Number one. Second piece is that there are situations where a fund manager cannot take any call by independently. Like let's say they are investing in a company in which one of the fund management team members are interested. Maybe the fund manager directly holds some shares himself, or maybe they procure some services from a portfolio company. Like let's say they are operating a bank account in a company, they have a lot of banking relationships, and yet the fund is investing in that same bank. So there could be many situations where a fund manager, if he goes ahead with a decision to invest in a company, can later on be sued by the investors that there was a major conflict. Why did you even do this investment? Or maybe you are related to somebody who's controlling the portfolio company, so you made the fund invest. All sorts of issues have happened in the past. So how should a fund manager sort of take a call? So what they do is they actually take the advice from the advisory board that this is a situation where we feel there could be some conflict, and it is not like my own perception as a fund manager. There are well laid out rules on what areas of conflict are significant enough that a fund manager should actually go to the advisory board and take their advice. So in those cases, advisory board members have a view. Sometimes what is happening is, like, if you have again institutional investors like IFCs or others who are also or any investor who is also making direct investments in India, and the fund manager is looking at a deal, there is some conflict. You may also have a situation where a investor on the advisory board also is conflicted because he's also investing in the same deal as the fund is investing, or maybe there are clauses in co-investment terms that either I will also invest as an investor alongside the fund in the same deal, or if the fund does not do a deal, maybe the advisory board member who's also an investor can also directly make an investment. So all sorts of conflict-ridden environment is coming up more and more in Indian context, which is why we feel advisory board does have a role. Now, does it add value? The value could be that a lot of funds in India still tend to be raised by from institutional investors, and at the same time also retail type investors. So retail type investors could be 50, 100, whatever, and there are few institutions who are controlling, let's say, 70, 80% of the investor book of the fund. So instead of writing to all the investors, oh, that there is a conflict, like 130 investors will receive a note that there is a conflict, who may or may not even realize what is the significance. They may feel that, oh, something adverse is going on, or are we being, defrauded or what. So instead of that, let's have a more sophisticated discussion with the larger investors who anyways will understand the issue, will have a global experience, and accordingly advisory board again there plays a role, because instead of running the conflict with the entire investor base, we have chosen 6 7 whatever number of larger investors, and if they agree with what we are doing, then at least we know that our investors are supporting. I know it's a long answer, but I just thought you should have a perspective.
Why can't we have a conflict committee? Because there can always be a conflict committee, because the role of advisory board, one is to look into the portfolio, uh, which is investment manager's responsibility, IM's responsibility, but major portion looks like a conflict. So I can always have a conflicts committee and do away with advisory board.
See, again, in a PVC environment, that may not always work for the simple reason that who will be
Like with the conflict policy. So these are
yeah, no, conflict policy is fine.
Right.
You can have your own internal conflicts policy. You can say that, let's say I'm an institution in India myself. Let's say I'm a big bank franchise, and I have multiple conflicts running at any point in time. I have a bank which is lending. I have a P arm which is investing perhaps in the same company. I have different verticals who may somehow converge in the same portfolio company. So in those cases, maybe you run certain conflicts through your own internal conflicts committee,
Right.
and you let your investors know who are the members of that conflict committee. Are they also motivated to clear conflicts more easily than, let's say, something which is completely investor driven? See, the greatest transparency you can have in a conflict is to the investors whose money you're handling. If they themselves feel that this deal should not have gone through, the worst case that can happen in a conflict committee situation could be that investors could sue the committee itself, that you are not part of the investors, your interests are not completely aligned with that of the investors. So that alignment of interest is the gap which independent conflict committee cannot always clear. So yeah.
On the advisory board, have you guys seen the emergence of, like in corporate governance, independence?
Right.
Is
No.
is there acceptance? Is there
No,
trends
there's no
around
appetite
it?
also for that, and I'll be very clear, because advisory board is only meant for LPs, and typically now that we are going to nuts and bolts, uh, uh, construct your LPAC or advisory board investor committee in a manner that at least they represent 66, 60, 70% of your investor base. So if they give you a green light, your investors will not have a difficulty. The moment you start getting independence, then who is truly an independent? Why is he an independent? Why have you chosen? Have you, the manager, chosen, or the investors have chosen? If the investors have chosen, then may as well have an investor representative only sit there. So, yeah.
You talked about the key person event, changing it from key person to key designation event. Are LPs buying this concept? I mean, have you seen examples where people have investors have bought into this concept on the institutional side?
Uh, okay, they have. If institutional investors, you are asking for institutional investors or institutional managers, because
Investors. Ultimately, it is the investor who has to agree.
right.
Manager
So
doesn't make a difference.
it actually, that is what makes the difference. As an institutional investor, you'll never go with the designations because you can always replace somebody X with a unknown Y, right? So what happens is, if you are, let's say, investing in a global franchise like a GS or a MS, or even India, if there are some larger banks, right? So you are relying on the capabilities of the institution which is out there, and you wouldn't want some one individual to literally take the manager to ransom. What if a bank in India, or let's say a larger franchise, names some individual as the key person? Then that person can sometimes take the entire GP to ransom, that if you don't, I'll resign. To avoid that situation, and to the conversation with the investors, that you have entrusted your funds with this institution and trust us that we will replace this individual with somebody of an equivalent CV strength. In fact, we'll tell you another example where a senior fund executive was actually poached by a rival GP. This triggered a keyman clause in Fund X, and because of that, the Fund Y, which is where the GP went, actually told the investors that why don't you come over here. So
So this is public. This was last year. The head of the real estate division of CLSA Partners, he shifted to KKR, and he was already running a $1 billion plus fund, and there were millions of dollars drawn down, hundreds of millions of dollars drawn down, and there were also some LPs who were common on both funds. So there was also talk of whether this is a business strategy in itself, acquiring this key person, and then how do LPs react. So this has happened, and he was in CLSA before that for 15, 16, 17 years.
There is normally a cure period, right?
yeah, but
Yeah,
the
there is.
cure period also means, maybe if you want to add to.
No, sure. But that cure period also, you need to find an appropriate substitute during that cure period, which could be tricky in a situation like
Like
this.
this.
With an 18 years of
Like when the guy
experience
who
in.
raised the fund has left the fund. So
Okay. Unless anything else, you can move on to the.
Okay. Next on cause removal of the manager. Here, two, three contentious points. What constitutes cause, and how do we determine that cause has occurred? So, typically, in case of any commercial transaction, you would want to restrict it to bad acts, which is fraud, gross negligence, willful misconduct. However, in the context of a fund, LPs also request for material breach of fund documents or applicable law, or sometimes even a criminal conduct which is not related to the fund. So, if you've identified, say, a CEO level key person, and that key person has been known in the market or publicly to have engaged in any criminal conduct, even though it had not impacted the fund or the investor, sometimes LPs request that that also triggers a cause event. Uh,
Yeah, I think I'll just add, though it's a anecdotal point. There was a litigation actually in Cayman around what does cause really mean? Is it a material breach of the agreement, or a breach of a material clause of the agreement? So, like, if there was something to be submitted in 7 days, you don't do it in 3 months. So, what was a breach of a very nominal sort of a situation, but you have materially breached it by delaying it for such a long time? Or it could be a breach of a material term, like, okay, you were to give investors some reports and you went about it without keeping them aware. So are you breaching a material term, or are you materially breaching a term? I think the drafting there, because it was taken up for litigation grant court. So okay.
Yeah. So with the cause provision, actually, it's the drafting that's the trickiest, because, like I said, sometimes you receive a markup from investors which requires any bad act, whether or not related to the fund, to trigger a cause event. Then the question is also on who determines a cause has occurred. Can it be an investor just reading a newspaper and reading an allegation and initiating cause? Well, no, it should. If especially if a criminal conduct is involved, you should have someone appreciate evidence, an objective body who can appreciate evidence, listen to both the parties, and then come to an objective conclusion with respect to whether cause has occurred. Now, again, there is a dialogue here, negotiation here on whether it should be a court or an arbitral tribunal should suffice. Sometime expert determination is also pushed for. Expert determination is when you just appoint an independent expert mutually to see whether a cause has triggered or not. Uh, then the third issue with respect to cause is the consequences of uh, the economic consequences for the manager. Yes, you would trigger a removal for the investment manager. You would probably want the sponsor interests also to be shifted to the new GP team you would identify. But should there be a haircut on the fees and the carry? There is again a case to be made for fees that I understand carry is my performance driven income from the fund. But with respect to the fees, I have to take care of the expenses I have charted out for the next year. Because of this one individual or one team that the cause may have triggered, I can't let the institution not uh, not service its expenses. So at least for the fees, don't apply a haircut to me.
Yeah, I think just to caveat, our views change depending on who's in the audience. GP audience, this is the view. LP audience, we could have said something different also.
When you're talking about the
That's
manager,
for all
you
the
mean
terms, actually.
when you're talking about the manager, you mean the investment manager, not the individual, right?
I think,
Yes.
yeah, you
Under the
may have
laws,
used
it
it.
is not the individual that you're
Yeah.
talking
So
about.
it even with respect to an individual in an institution, a cause can be triggered.
But that will be under the key person event, right?
No, it
Or-
need not be. It need key person event triggers when you are not allocating sufficient business time to the fund. Now, if you are allocating sufficient business time but have also engaged in a criminal conduct on the side, you need not trigger a key person event, but it would trigger a cause.
No,
Could you
because
repeat the question once
see,
again?
the question is that when you say cost removal of a manager, you're talking about the manager here
Is
refers to the
the entity
investment
itself?
manager.
No, the entity itself.
Entity itself, that's
Yeah.
not the individual.
Correct, correct,
Not
correct.
the individual.
So when a cause has been triggered, the cause
It's
can be
against the
triggered by some particular individual did something wrong, but yet the institution as a manager will be removed.
Absolutely. Yeah.
Yes.
So the LP has no relationship with the individual.
So in some cases, we've actually seen the individual being removed instead of the manager. So the managers have actually come to agree that if it is an individual causing the cause and it's a junior level individual, then let me just replace that individual. Let me immediately terminate its
But
employment
in
because
an LP agreement or a fund agreement, that won't trigger it, right? Because
you'll
there's
you'll
no
impose
relationship
the
between the two.
I agree. The investor does not have any direct relationship with the
Exactly.
employee, but the investor imposes an obligation on the manager to ensure that that employee is immediately terminated.
See, maybe as a package for cure. See, like whenever some event arises, the investor will also need a situation to be explained and all that, right? So at that point in time, the investor sometimes, as their feedback to the manager, could say that how can you cure the cause? Is the cause to begin with curable or not? Like something where there's an institutional failure like of the sorts that you saw in a Braj or otherwise. There's a institutional issue versus let's say some junior employee or any part of the team, and it's a broader team, is known for on a personal level something has happened, then can we cure the cause by simply removing him from the team?
True, but that will not be an issue that will come into the fund document. That will be a part of the manager's internal structure, right?
See, okay, I agree with you. All I would say is that sometimes it comes into play if, let's say, the fund manager is a institution, like one of the again, like I said, bank or any of those franchises which also have a management arm. They would say that in case one member of the team is known or discovered to have indulged in something which is reputationally not the best thing to have happened, then we are hardwiring the cleaning up of the cause right now. That if we remove such member, you won't then again examine it again as cause. So hardwire the solution on day one so that in case something like this happens in future, again the GP does not have to interact too much with the LP that what should we do or are we out of the game.
But in case of where the GP is not institutionally backed, and there are individuals who are sponsors, acting individuals, the president and put in the sponsor commitment, then this will not work, right? Irrespective of what is written in the fund documents and we could just be into the GP, the individual will be responsible and they can terminate commitment.
Absolutely. Absolutely. So like I said, this is a very exception where some solution is also provided that how can we cure the situation, but otherwise LPs will never agree to something. Yeah.
So, the legal issue which arises with these governance provisions, A, we discussed fiduciary for advisory board. When you're removing the manager, there is also a SEBI angle for an AIF, right? You need a SEBI approval if you are changing the sponsor or the manager. So, you need to factor in that time for SEBI approval or other regulatory approvals while you are designing cause related removals in the fund documents, right? Uh, then on early termination of the fund, we have seen key person events and cause related events also snowballing into early termination, or there being absolutely no fault or no cause, and 75% investors by value just coming together and deciding that the fund will not progress from here and it's time to wind up.
Yeah. See, ultimately it's still a theoretical point. Practically, I can't think of any fund which has terminated early. Either the manager has been removed. There have been several cases in the past. The manager was removed. There was an auction bidding that we have a existing portfolio. So tell us, can you get us an exit for this portfolio? And there's a bidding. And as a manager, you bid and you will be paid certain only to get a portfolio liquidated. So there you become a portfolio manager, not a fund manager. Or in another instance, we have seen the manager being removed and the new manager being hired, in which case you do a haircut on the fee, carry, and so on so forth, and the new manager sort of takes up the role. But again, that has been very, very rare and only one in Indian context that I can think of.
Next on successor funds, changing is the threshold for determining when you can launch the successor fund and what all can a successor fund do. So, can you just should you just put a restriction on the first investment by the successor fund, or should you in fact not even allow raising a successor fund unless this fund is up to 75%, 85% invested or earmarked for investments? Uh,
Yeah, I think these clauses are this clause in particular has been very important in Indian context. What had happened is in the past, LPs were not very comfortable with a larger fund raised by Indian fund manager because they thought that you have so much of undeployed capital, dry powder sitting with you. Why do you need a new successor fund? You'll only be earning your 2% on the large corpus you have raised. So even though the performance were not subpar, yet the LPs insisted that you, the fund manager, only raise a fund size which something you can deploy in next 2 years or 3 years. Raise a new fund. We don't mind that, but don't increase the size of the fund where the management fee leakage is far more than what we want to budget for. So there, the fund managers under pressure that okay, within the next 3 years, as soon as I finish the deployment of this fund, can I quickly get on the road and start my next fund? So there, the successor fund clause has come of much relevance. I think.
Also, I think sometimes the understanding of what is a successor fund in the fund documents become important. Like Nandini said, there are maturing GP houses and they may run different strategies. So, for example, if you're setting up a private equity fund as a GP, you may not want to restrict your ability to start a debt fund even in the next 12 months. So, those are also certain negotiated items that are played out.
Especially if you have a diversified team. The team cannot ideally should not overlap, otherwise they'll feel that you're not putting sufficient time into this. Maybe fiscal discipline.
Yes. So fiscal discipline is something that LPs, while they are in case of a blind pool vehicle, while they are trusting the manager with almost all fiscal decisions, there are still a few which the LPs like to control in the fund documents. Uh, One is return of unused capital. So there can be practical situations where you've drawn down capital and then the deal does not go through, or maybe a portion of the amount that you've drawn down is not being utilized for any given reason. then in that case, you would be allowed a particular period of time, typically to retain the funds without running an IRR on those funds. But then you would be required to return those amounts to the investors and add it to their unfunded commitment, or adjust it against an immediate drawdown available within those many period of days for you to not incur an IRR on it.
Yeah, I think, but just to add, a lot of recent fundraisers with institutional investors, there is 0 days of unused capital. You have to run an IRR right from the first day you drew down. So you have to be very careful on when you time the drawdown and immediately return it back if there is no use.
So is it
Otherwise,
the day we receive the fund or the last date in the capital call notice?
as a fund manager,
Yeah.
see, IRR to begin with is every investor by investor.
Right.
Number one. Number two, if you are dealing with too many investors, you may want to write the date mentioned in the drawdown notice on the last date of receipt of money. But the problem is some investors may delay their payment.
Correct.
So in their case, instead of considering it as a default, maybe you thought, okay, let it be. Then let the IRA start a little later. It's also relevant if some investor, upfront says that take my money right now, I won't have money after whatever 6 months, 7 months. Then again, I can't give him the IRR on the full right on the day he gave. So there, the drawdown notice is more relevant than the actual date of money coming in.
So how does one decide? Typically, I would assume it would be mentioned in the standard GPA. How do they decide what the time period after which you say, okay, this much is unused capital, you need to return it? Because typically one would say this is dry powder. I'm looking at possible investors.
There's a difference. Dry powder is when you have not even drawn down money from the investors, whereas what we are talking about is when you have drawn down, it is sitting in the fund's bank account in India or wherever the fund is. It is not with the LP anymore. Dry powder is the money is with the LP. You are yet to ask for the money. Whereas this is about a situation where the money is no longer with the LP and it is in the fund's bank account. LP may say that I could have used my money in a better way than how you are using it. Hence the IRR expectation.
So I was talking about just the part where they have called it, there's a capital call, you call it, and it's lying in the fund's bank account. Typically, what is the period by which there would be some thing on that, in which you have to deploy it, otherwise they call it that?
No, so that's also a negotiated item that your documents stipulate. Typically, it's around 30 to 60 days, man.
Okay.
Beyond which,
Basically less than 3 months.
yeah.
Anyway.
Only if your LPs did not have negotiation power. Like I said, LPs today insist that right from day one, you have taken the money,
Yeah.
you are on the hook.
In the case of now that you're seeing the new trend of platform investments, right, where the fund itself basically starts off either a food services company or a housing finance company or something like that, where you basically make a huge commitment. So you could actually draw down and keep the money in the fund or in the platform vehicle that you create for that. Do you find clauses that are coming in the LP agreement to restrict the return of unused capital either at the fund level or at the platform entity level?
See, we
I
have
mean,
done.
technically, I can
Yeah.
draw down and park it into the housing finance company, which is then use it over 2 3 years.
See the okay. So we have done few of the platform transactions on the real estate and infra side, and you would know the names, right? So a lot of Dutch investors have done this with real estate developers in India. So there, unfortunately, the position is no different from how you would do it in a P. The view is very simple. Doesn't matter what sort of platform you're running. Money not sitting with me, but sitting with you. You are on the hook if
From
I'm the
IRR
investor.
block, yeah.
So it's a very simple policy, and it's very LP friendly, right? As a GP, it's up to you. Can you negotiate that? No, these are not like electronically, like the opportunity is there, and I'll time it right. There are FX issues also out there. Like even in the master feeder that Nandini was discussing, you could have 14-day drawdown notice from the India fund, whereas even if your global LPs have sort of put the money in the feeder, from feeder to India also there could be weekend or whatever. So you may have a 2-day buffer in between. So 12-day notice there, 14-day here, despite the fact that drawdown notice would have been issued simultaneously. Still, but you're on the hook.
No. So my question was basically how do you prevent, how are LPs preventing the use of capital? So for example, if you draw down capital and don't use it
Hmm.
for a transaction, then you're technically required to return it back, right?
Correct.
Which is the return of unused capital.
Would it answer your question if I say that even if you do temporary investments, things like FDs or bonds or whatever,
Yeah.
and if and increasing the LP say that the cash generated from that either will not go to the waterfall, that is very aggressive, but it is also positioned LPs take that you drew down for some purpose X, the fund strategy is purpose X, but you ended up doing Y. Accordingly, whatever you generate is not going to run through the waterfall. So A, you're on the hook for the IRR, but B, that money is not going to the waterfall. So perhaps that, or alternatively, as a GP, you say that if I have not been able to do anything, but I've parked it temporarily into something because I thought the opportunity will materialize, or if this deal didn't happen, the other deal will sort of materialize. Then at least let this cash flow run through the waterfall. That's the compromise that you can do. Okay.
I think we discussed calculation of IRR on how to compute it. Should it be the due date in the drawdown notice, or should it be the actual receipt of the monies into the funds account? Temporary investments also, like Richie discussed. So how they use it as a measure of fiscal discipline is, do not draw down monies for making temporary investments, and they define temporary investments very carefully. So it should not be for longer than say 60 days, or it should be in these credited for investments. It should not be in investments that you do not wish
Yeah.
you would make directly if you had the money. So, from a fiscal discipline perspective, A, you need to identify what temporary investments are. B, don't draw it down for making temporary investments. In fact, if you have unused capital, even for that 30 to 60-day period, make sure you park it in a temporary investment before returning it to me. That is the extent to which they want the unused money to be valued at the fund level. Then last is on fiscal discipline, investor give back. Here, this is a mix of legal, tax, commercial issue always. They do not want you to take exposure in the underlying portfolio beyond what you are agreeing as their liability in the fund documents under investor give back, right? Investor give back is a provision which allows you to call back the distributions that you've made to your investors for any liabilities that have arisen at the fund level. These could be post termination or during the term of the fund. They are mostly post termination because during the term you would have unfunded commitments to draw down for, or you would have reserves created, or you would have an active insurance. There are different recourses available before you would trigger a return of distributions from your investors. Your investors also see this as a measure of last recourse and as a very limited measure. So they would want a limit of which can be referenced to their commitments or the total distributions made to them, or the total contributions that were drawn down for the amount that you can call back under the investor give back obligation. Also, you need to draw a distinction between a fund level liability and a investor level liability when it comes to investor give back. You can call distributions back only if it is a fund level liability. In a tax pass through vehicle such as in a category 1, 2, or even 3 AIF in India, you may you may face a liability which is specific to a single investor, because you have different tax status for different investors. And if there is, for any reason, for example, if there was an investor who gave you a representation that they are tax exempt, so you should not withhold anything from them as a foreign investor who is tax exempt for a particular stream of income, and later you were to find out that that was a bad representation, there is a request from the tax, a demand from the tax authorities to call for that tax which was considered exempt on wrong basis. Then in that case you can't trigger an investor give back. What you would trigger is a specific investor level indemnity. You can't penalize other investors for the bad representation of a single investor. So yeah, these are some matters of fiscal discipline. Then
Sorry, on the one of the key points on give back is period of give back. How
Right.
long after the fund life can you actually trigger it? And one peculiar India situation is that the tax authorities can open your books for around 7 years, and that is unusually long for international LPs to digest. And after the renegotiation of treaties and the foreign exchange restrictions being eased, a lot of those investors are coming in through unified structures, like Nandini mentioned, where possibly they signed up to a Series 2 or Series 3 fund, where they maybe had a 2 to 3 year give back window, but suddenly they're looking at a 7 year give back window in the Series 4, Series 5 of the same GP. So that involves some explaining to do sometimes.
Yeah, see, I think to begin with, I hope you understand the concept of give back. Give back means as a fund you have given some returns and distributions to the investors, and after some time, the period which Shrikant summarized, you want that money back. So obviously, it's not a very good conversation to have when investors are very cagey about it. Hence, all the bells, whistles, restrictions around it.
And in India, since most of them are set up as trusts, the trustees also have a keen interest on this particular clause and seeing that what you're agreeing with your LPs is not something that even they are able to manage.
Just one thing on this. So when you say suppose you disclose this in the documents that you prepared, especially in a master feeder structure, you disclose that there may be a which will park as a reserve for a certain time period. Do you also invest that somewhere? And what about the interest that you generate on this
See, it would
reserve
be
which you
very
invest?
unusual to park some cash in a reserve
So how do
because
you?
so I'll tell you. See, what has happened is I can think of two scenarios where this can happen. If you are a closed-end fund like a category 1 2, you have, let's say, exited all your investments, but there's some pending tax litigation, and you feel that you have not withhold fully, or the department can come back and there's a good case. Then because you are dealing with a trustee at the back end, and the investors will go away, the manager is also contractually out there. The trustee is anyways a representative assessee. So what they should say is that we will not allow you to surrender the PAN and close bank accounts, fund a reserve and keep it on the side till that litigation is resolved. So that can also, like Shrikant indicated, goes can go on for a while. So that could be one scenario where you fund an escrow, and yes, you can invest it temporarily because there is no restriction that it can't be interest bearing or anything. Investors may insist that in case you earn any income out of it, it will be passed to the investors as per the waterfall, though the actual legal entity has now been liquidated, but this account will be separate. The second instance I can think of is something like a Cat 3 situation right now that we are grappling with, where there's a apprehension that could FNO or short-term churn could be treated as business income, even though at least on capital share equity shares, if we take a position, it's all capital gains. We may have paid 10%, whereas the tax could be much higher. So in that case, if investors don't agree to a give back, or they are like retail type investors whom you cannot hold on to later on, you may then fund a escrow or a reserve and let the investors know that okay, we have kept it separately for you. In case a demand comes up or crystallizes, we'll use it. Otherwise, this will be distributed after 3 years or 4 years or something like that.
So in case of an open-ended structure, it is better
Precisely.
to disclose to the client and then do it this way, like you suggested.
Correct. See, extreme case would be that we'll pay the full tax, you claim a refund, or
Yeah.
we'll fund a reserve, or we'll keep you on the hook for indemnity or something of that sort. Some compromise will have to be reached. This issue, by the way, also arose in case of mortgage funds when the treaty got renegotiated. Now you have a FIFO method running, first in, first
Yeah,
out.
exactly.
You
There's no
liquidate something
resolution on
for,
this.
so exactly. So in those cases, you sometimes can also think of a reserve.
Next on LP rights, this again is more relatable to institutional investors or investors, even strong family offices. Generally, HNI audience or retail audience would not push for these rights. The first is MFN and carve out. So, MFN, the most favored nation clause, is a typical side letter provision. The nomenclature derives itself from international trade laws, where basically an investor who is agreeing to certain terms in the side letter is telling the GP team if there are other side letters with other investors who have also been given special rights, then please disclose those rights to me and allow me an option to elect those rights for myself as well. Now, obviously, the GP team would want to restrict those this MFN right only to equal investors or investors who
Lower.
are lower than the investor asking for this right. There can also be certain carve-outs if you are giving a special right to an investor because of their special legal status, their statutory status or tax status, which does not apply generally to all investors. You can choose not to provide that special right under MFN to all investors. Similarly, you can actually carve out even special economic rights on different basis, different parameters. Then the second is on co-investments. This is again a side. Sorry.
So vis-a-vis MFN and all, what is SEBI standing on this? Because there were recently some discussion paper which was quoted. There were issues around, multiple investment in PER and
On side letters to begin
on
with.
side letters and all. How
So
does that affect on the
so
AIF
okay,
side?
okay. So let me put it this way: SEBI believes everyone should be given MFN status, right? Because why
But
should you
that,
have anyone at a better term?
no, no,
Let everyone be at the best terms.
but on a closed-ended fund where there are only educated and not non-retail investors in place, there are side letters yellow which pretty much is name of the game. Do they have in Cat one funds which are closed-ended on the unlisted side fully? Does SEBI have a view there? On the listed side, I can still understand, but on the unlisted side, do they still have formed a view?
So not a formal view for sure. We did not see any circulars, notifications, amendments coming out at all.
Because the fee structure varies from investor to investor, right? My anchor and cornerstone investor might have a differentiated fee structure vis-a-vis somebody else.
So sometimes in fund documents you can write that we'll charge up to two, and give enough clues in the fund documents that an investor can negotiate something lower, and on that basis you have the bandwidth to move the slide at what specific percentage you will charge. At the same time, it is more advisable to have different classes,
Yeah, this
so that it's all transparent, and identify the ticket size at which you will give a discount, right? So tell investors that bring in, I don't know, what is the ticket size you would consider, a million, 5 crores, or whatever, and we'll give you this much or that.
So that's actually the comfort you give to SEBI if at all SEBI asks you this question, right? There's adequate disclosure, then SEBI should be happy.
And what are the thoughts around if some investors and all also seek a share of the carry, then how does that get assessed? See, so you can still have all these.
So I think carry is never part of the fund documentation to begin with. That's more like
That's a GP's prerogative.
that's a GP's prerogative, and that too the class of GPs will allow an LP to invest in the GP. It's completely conflict ridden. So we wouldn't usually recommend for LP participation in the GP. But yeah, if that is the economics, you need the some investor support to meet the sponsor commitment or whatever. Then in that case, you'll have to be very careful in how you customize the documents. But it's got nothing to do with the fund.
But again, for sponsor, you can have different class, and for carry, you can have a different class. So that,
No, no. I think your question was that if a investor only wants to invest in the GP, the fund manager entity, legal entity. I thought that was your question.
That's also one of the part of the question. You're right.
Does SEBI allows it in such kind of where you can spread the carry?
See, I think there are objective and non-objective issues. Technically, as a fund, I can issue any class of units to anyone. But carry is meant largely more to align the fund manager for the performance of the fund. So usually it's meant for the franchisee, the management entity, the key individuals who are part of the team, and so on and so forth. So there is I think the June 2014 circular which allowed carry to be issued even without contribution by the team.
No cost units.
No cost units could also be issued for carry. So which means that they in their minds are clear that it is for team incentivization, and it could be seen as a perquisite, like a salary equivalent of sorts. So let's not have any 1 crore or 25 lakh ticket size attached to it. Now, if you decide to issue carry units to somebody who's not part of the team or the manager, whether investor or otherwise, the ticket size would come back into force. You contribute 1 CR.
Within SEBI is okay, like if those terms are, because in side arrangement parts, SEBI was not very much appreciating to our different.
These are two different issues we're talking about. One is, can a fund issue side letters? Can a manager enter into side letters? SEBI's question is, or concern is, that we want complete transparency. Through side letters, what you've written in the PPM and your fund documents versus what you practically play out are so different You can write a new fund only in a side letter technically, right? So SEBI wants to discourage those practices, which is fairly standard across all mature regulators, all ISCO members. SEBI is also learning or taking views from SEC in US. So there are a lot of restrictions on side letters globally. So SEBI's view on restriction side letters, one piece, whether you can incentivize an investor or some distributor who's saying give me a piece of the carry, that is a separate. Can you disclose it? If you disclose it to all your investors as a conflict, that is a good enough position. Okay.
Next on co-investments, again, this is typically a side letter item. So the different trends that we are seeing is whether you want to co-invest through the fund vehicle itself, or do you want to co-invest through a separate co-invest vehicle, whether there should be a fee carry component with respect to the co-investment as well. To what extent is the manager required to manage the co-invest? Should the exits be timed equally? So these are the different kinds of discussions on co-investments right now. Then there are certain veto items. Again, this is a very DFI or institutional investor driven points. They are internally required to impose certain policies on not just the fund in which they are investing, but even in the portfolio in which the fund is investing, like the ESG policies or anti money laundering, financial corruption policies. And they require veto rights on any amendments to these policies. These are conditions precedent for their investment into the fund. Then again, they have certain formats. Often becomes an operational issue for fund managers. There could be five investors with five different formats being agreed in their side letters. Usually, the intent is to agree to say a standard side letter which could be globally agreed by an LP body. And same for distribution notices and reporting formats. But there you would still most likely end up with at least one LP who requires it differently in their format. Uh, then there are default exceptions. Generally, LPs say that, okay, if at all I default, don't forfeit my units or don't take these five actions against me. We can agree to different actions. And then there are excuse provisions. There is a list of prohibited investments for certain LPs. They don't want their money to be going in certain industries or in certain portfolio companies which have been known to have committed certain acts. Uh, these are some highlighted side letter items. Then on legal and tax considerations with respect to Indian AIFs, the first question that we often discuss is how do different documents go with each other. The most relevant discussion is on the PPM. We get asked why is the PPM important? Why do we have to draft it? Do we need to sign each page of the PPM? What value does it hold? Now, from an AIF perspective, SEBI looks at your PPM while assessing whether you should be given an AIF license. So, even to your investors, you need to make it clear, especially global investors who do not want the PPM to be considered a legal document or a binding document at all, that you are under a regulatory obligation to ensure they have read the PPM. For the regulator, it's not the contribution agreement, it's not the indenture, it's the PPM. And different items in the PPM. You have to have a conflict policy which is built in. You have to have risk factors which are adequately disclosed to all your potential investors. Your key fund terms also need to reflect properly in your fund term section of the PPM. So these are items, to the extent you want them legally binding, you would incorporate in your legal document, in your contractual documents. But from a SEBI perspective, you can't shy away from disclosing them in the PPM as well. Then on which sort of document takes precedence over which other, it's a matter of discussion and how you design your documentation. There are no thumb rules as such, but generally the charter document of a fund should, of any legal entity in any construct, should always prevail because that charter brings that entity into existence.
There's the trust deed in Indian context.
Yeah, an example is the constitution would prevail over all the little statutes that we have, right? So similarly, in case of a trust, the indenture of trust which creates the trust should prevail over all the other documents. Then indemnities we briefly discussed. There should be a distinction between fund level liabilities and investor level liabilities. There is a fund indemnity, which means manager and trustee are indemnified out of the fund assets, and then there is investor level indemnity where the investor indemnifies the fund, the trustee, or the manager. Then on dispute resolution, the ongoing discussion is whether arbitration works for a trust, because there was a Supreme Court ruling in I think 2016 where it was held that trust disputes in India are not arbitrable because there is a remedy of civil courts given in the Indian Trusts Act. So you go to civil courts. You can't contractually agree for an arbitration provision in case of trust disputes. But again, the AIF regulations allow you to agree to an arbitration mechanism in your fund documents. So there is a fair amount of document designing required for you to achieve optimum results. Even as GP, you would want a speedy recovery for any commercial disputes arising out of the documents. So it's in the best interests of everybody that you figure out a solution for an arbitration or an expert determination to be enforceable for your AIF. Then on tax considerations, I think these are more relevant with respect to open-ended structures, and we can discuss them. I think
Yeah,
in
during the
that
next
session
session.
too.
But if you have any tax related questions, we'll be happy to share some thoughts. Okay.
The last one is on tax and regulatory aspects. So I think we've in the course already discussed all of these points. If there is any specific point that you see you would like us to pick up, we can do that. Yeah.
Sorry, I came in a little late. My name is Manoj. Uh, I just want a little more better understanding on the IFSC. The IFSC.
See, yeah. So FSC is the gift city structure, right? Okay. So what exactly do you want to? If you set up the gift city AF, that is what we were. Any structure today we talk about gift cities discussed. Like, can we put gift in between the structure? Can that make investments? Should that be the place where we pool investors and so on and so forth? But the view that we are sort of having right now, there still are some moving pieces. I think wait till the budget is announced, first week of July. After that, some more clarity required, and then we should be able to launch. I would think so.
Just one question on that ARC. You mentioned that there is a possibility of making an argument on no P no tax theory. Uh, no, typically how would it work? Because only institutional investors are permitted to invest in ARC. Taking the same principle as that of an FPI, they are always allowed to have capital gains and not business income. So how would that argument be tenable?
Sure. So there, I think there you're right. There is a dual assumption, and there is some gray which is still there because there is an assumption under the tax act that the securitization trust is itself a self-contained regime. There is a pass-through provided, and that the characterization is crystallized at the level of the trust. So if the trust has crystallized it as business income, what it passes on is business income. B, on the other hand, you're talking about another deeming fiction where the FPI and what it holds is a capital asset. And so the income, is it a capital income or a business income? There is that gray. So you are right, that conflict is there, which is why the argument which can be taken is that it is business income because it's crystallized at the level.
There another concept which is really the depths. It says that you have a theory of significant economic presence, and this is your thought. How do you feel that that theory will get extrapolated to these kind of investments, especially when there is a constant interaction with India as a market by the foreigners?
So, what's the question exactly? What do you?
how do you foresee BEP's significant economic presence playing a role in these kind of fund structures?
So let me still answer the previous question. To begin with, when a securitization trust is upstreaming cash flows, those are on the security receipts that the SRs that the FPI holds. If the FPI were to redeem those security receipts, or if they were to transfer those security receipts, then you are attributing a capital asset sort of view. But the moment you are only upstreaming cash flows, whose characterization has already been fixed, like Shrikant indicated, as business income, then in that case, the chances of a business
Correct.
income is far more than capital asset.
Here again, it turns on the trust documents because some trusts may redeem the security receipts in order to give returns. Some of them may just pass it on. So
Yeah.
there is also that interplay which is to be understood for a tax treatment.
Yeah. On your second question on BEPS, so BEPS is base erosion profit shifting. I hope you're referring to that. So there is a global push that can we de-layer structures instead of having three, four, five layers of entities between investors and the asset class. Can we have investors coming through one pooling vehicle and make investments? Now BEPS has pretty much influenced a lot of what we do. The simple reason is that earlier you used to have a feeder in Delaware, a feeder in Cayman, tax exempt investors coming through one vehicle, check the box, pass through K1s for taxable investors. They come in Mauritius. Mauritius in turn then invest in India, or there could be one master above the Mauritius vehicle also. So, a lot more of the structures that we design today have eliminated all of this. The Mauritius itself acts as a pooling vehicle for, let's say, taxable investors, a separate vehicle for tax exempt investors, and this directly invests into an AIF or it makes direct investments in India. So that we have eliminated a lot of vehicles which were otherwise used traditionally, but obviously under advice of US advisors so that they can defend the structure later on.
And
Just,
BEPS, sorry, on BEPS also, I think two aspects would need to play out. A, BEPS itself is not a law, so BEPS needs to be implemented in some way or the other into Indian law. One of the more popular ways is the MLIs. MLI is one of the articles of BEPS where a lot of countries have come together for the multilateral instrument, and what it does is on a treaty by treaty basis, it affects by introducing certain anti-abuse measures. So literally, you'll actually also have to do a treaty by treaty test to see how significant economic presence may be understood if it is part of that MLI and that treaty which you're looking at. So there's a lot of things to settle even for BEPS and for MLI jurisprudence to understand how it affects the
As
treaty.
a recent development, we are already approved
Yeah.
MLI has been ratified.
Yeah, I think yesterday or today it's been signed. Yeah, yeah.
in fact, I'll just add one more point for the broader understanding. So, there's an Article 7 also of BEPS which says that it is no longer that somebody in India has the authority to execute contracts for an offshore client, which will lead to a permanent establishment analysis. What they're saying is that now, if somebody in India has the authority to advance the negotiations on behalf of an offshore entity, even that could constitute a permanent establishment. So, what used to happen is that the advisory team in India would lead the negotiations, but ultimately the documents would be signed by the board of directors in Mauritius. So, even that now technically could come under a lot of scrutiny if this Article 7 of BEPS goes live. Just the fact that you could lead negotiations. Okay.
So, unless there are any other questions, I think we can begin.
On the safe harbor regime for fund managers, are you expecting anything in the budget or any developed interest from the fund managers?
See, I think there are 9 approvals which have also already come in under 9A. I think if that is what you're referring to. So I think that there is some relaxation already coming in. Those who can go for 9A are going for 9A. Others are looking at Gift City.
So I had a slightly different question. Uh, is it possible for us to look at this through an NBFC route rather than a trust route? So raising money and investing instead of going saying we'll only do an AIF. Can you do this through an NBFC? Have you seen that happen? What are the pros and cons?
No, not really. So these are not substitutable at all. NBFCs are, at least the perception that we have seen from a fund stream perspective is that the idea is to build the business and later on go for a strategic sale or an IPO. Whereas an AIF is something where you upstream cash flows very regularly to investors and give them exits over a defined finite period of 8 to 10 years, because NBFCs to begin with are a corporate entity. There is a leakage at the NBFC level, and then you'll have to look at India's treaty with the foreign jurisdiction, and then see what are the other tax leakages out there. Whereas in AF is tax passed through, and there is no leakage in India. Only taxes you pay is on behalf of the investors. So it is very easy to understand, easy to explain, sort of a product regulated by SEBI, which is a far more benign regulator than RBI. And the third one is the product itself. AF is meant to only invest in NCDs or optionally convertible. NBFCs allow you the opportunity to originate rupee denominated loans. So, do you want to be a creditor lender, or do you want to be a security holder regulated by SEBI? And for the first time, we have seen all regulators come together to encourage AFs, right? Like RBI said, if the manager is domestic, even if you have raised $100 from offshore, full 100%, still you're a domestic investor. SEBI has said we won't look at what you have written in your fund documents as long as you have disclosed things and investor ticket size is 1 CR plus. RBI, with all this conundrum going on, we may expect even more tightening of the prudentials. Whereas SEBI, on the other hand, is on the path of being even more deregulated. So I see very different paths, directions, uses, and purposes. Yeah.
Yeah, I think we'll have an
Sure,
offline.
sure. Okay. Uh, any other questions?
When
Otherwise,
you
I
talk
think we
about
will.
the closed-ended fund,
Right.
what is the maximum duration which your fund, like can I have a 99-year
It
say
depends on the
suppose,
in the asset class. Let's say, taking that example, if you were to design a debt fund, what you could do is you could draw down from the LPs in the first 2 years
Right.
and keep on churning the cash within the AIF, not upstream it again. If, let's say, the AIF were to do NCDs
Right.
only, so let's say one round of NCDs you could get an exit in 4 years instead of upstreaming to LPs. Keep on churning. LPs are earning their IRR. So do 3 rounds, 4 rounds, or something, but then have some finite 10, 12.
Right.
So it's entirely driven by asset class. VCs could have 9 to 10, 12 years also defendable. Infrastructure, perhaps even 14 or 15 could be defended. So let there be some cogent link between the asset class and the term.
So, for example, we are coming with the AIF, which is a venture debt. We want to do it now. Not coming. So obviously through NCDs or some kind, not NBFC route, because NBFC getting a licensing, as you rightly said, RBI, there is a whole set of regulation. So we want to through NCDs and so through other securities. So can I have a longer term, say 30-year, 40-year? Or we have to be in the.
There are too many headwinds which influence. I'm sorry to interrupt. See, the thing is, whom are you marketing to? To
Right.
begin with, if you're marketing to treasuries or corporates or banks, tell them that instead of parking in a debt mutual fund, why don't you come in a debt AIF? See, because there is Innovent, there is Trifecta, Altaria. We are advisors to
Right.
pretty much all of them, right? So the point is that if you should first understand who's the investor you're approaching. Is their profile going to be like, okay, we'll be staying invested for 20, 30, 40 years? You can't redeem. Try to understand. In a CAT 2, you can't simply redeem the units and give selective liquidity to one investor.
Right.
All investors will be getting a exit at the same time. So your investment profile or the term has to also match the investor profile and the investor appetite. So assuming that your investors are agreeable to a 2030 term, to be honest with you, I would very much doubt if SEBI would be comfortable, because there are these prudential norms, not more than 25% in any single investment and all that. Now those limits are actually looked at the end of term of the fund. So for 25, 30 years, it's as good as saying that I don't care and you should also not care as a regulator. How do you monitor these limits at a 25, 30-year basis? So I'm a little skeptical on such a long term.
Understood.
Anything on indirect transfer, like for category 3 FPI or category 3 API, which upstreams to the foreign investors and then further up?
Yeah, there are issues, but the caveat is that there's a 5% qualifier. Investors holding more than 5%, only they are impacted by indirect transfers. And again, there are carve-outs for category 1 to FPIs. AIs may, if you can make an argument that the taxes have been paid here, can we not look at it? Again, you can design the structure in such a way that there could be loan notes on top. There could also be situations where you pay out dividends or bonuses at the offshore level. So, or perhaps if you're doing a transfer, you allow the new investor to come in instead of buying out or a secondary, allow subscription and use the money to give a redemption. So redemptions are out, bonuses are out, profit distributions are out. So there is some way you can always structure
Well,
this.
the bigger is on the fund itself, the fund management itself, because ultimately money involved in the investment, the fund will be.
This business is fraught with risk. I didn't have businesses.